Hello everyone, this is Mahek currently pursuing third year course from Campus Law Center, Delhi University. Currently, I am a legal intern at LEXIS and Company. Welcome to our channel. So today's topic of discussion is daughter as a Karta, a case study. The case study is about the Sujata Sharma versus Manu Gupta case. This is a 2016 judgment of Supreme Court, wherein the Supreme Court categorically held that a daughter after the amendment of 2005 possess the right of ownership in the ancestral property of a joint family, and also she has the capability to be a karta of a joint family, provided she is the senior most member of the family. So let's begin. What is the Hindu joint family? Hindu joint family is an institution having its roots traced back to the ancient patriarchal society, where patriarch or the head of the family was the unquestioned ruler. He has the responsibility of all the members of the family regarding their clothing, regarding their maintenance, regarding their shelter and everything. The institution of a Hindu joint family consists of all male members descended linearly from a common male ancestor, together with their mothers, wives or widows and unmarried daughter. The Hindu joint family is a bigger institution than the co-parsonary. Co-parsonary in ancient or in traditional in time, it includes only the male members up to the fourth generation, or we can say up to the third generation from the senior most member of the co-parsonary, which is known as the last holder of the property. So earlier daughters of the family were not included in the co-parsonary. Fine. So in the Hindu joint family, since it's a bigger institution, one needs a head to maintain the family. That head in the Hindu law is known as the Karta, who owns the responsibility of the whole family. Now the position before 2005 amendment that amended the section 6 of the Hindu Succession Act, the position was, as I have told before, the co-parsonary does not include women. It only includes the male members of the family up to the third generation from the last holder of the property. He is generally the senior most member of the family. The position of Karta is itself regulated by birth and is guided by seniority. He is the most senior person of the family, and after him the next senior person. It goes in the line. He has the power to take the property, to receive the joint family income from whichever source it may come, to decide what portion will be allotted to what family member, and they all have to comply with the orders of the decisions of the Karta. Since the responsibility of a Karta is a wide enough to include the interest of residence and maintenance of the family members, so the Karta itself should own some right or interest of residence and maintenance, along with the right of ownership in the property. Since past Hindu law, the Hindu law in a classic form, the right of ownership or a right by birth was given only to the male members. Females were not included in it, so they were not empowered to get the responsibility of the family as in Karta. But what happened after 2005 amendment is this impediment which prevented a woman to be a Karta of a Hindu joint family due to their not being a co-partner was removed. Section 6 of Hindu Succession Amendment Act 2005 said that a woman is also a co-partner and have a right to claim partition in their ancestral property of the Hindu joint family. So since they now owns a co-partnership right, they do hold a ability to be a Karta of the family, similar to the position was male earlier was holding. Now the case Sujata Sharma versus Manu Gupta 2016 is the case that deals directly with the problem that whether a female could be a female having a co-partnership right in the ancestral property of the joint Hindu family owns a right to be a Karta of the family, owns to maintain the family. Uh, so the facts of the case was very simple. The Karta of Dr. Gupta and Sons, Hindu undivided family, died leaving behind 5 sons. As time passed, all 5 members died, and the son of the younger brother declared himself as the Karta of the joint family. The daughter of the eldest brother, her name was Sujata Sharma, she was elder in age than that son named Manu Gupta, who claimed to be Karta. She herself claimed to be the Karta of his joint family because she was the eldest among all. But the contention of the respondent here, means Manu Gupta, was that the amendment of section 6 of the aforementioned act, means the Hindu Succession Amendment Act of 2005, granted only co-partnership rights to the daughter, but did not extend these rights to for the management of Hindu joint family, because two things were there. First thing, the membership of a daughter ceased to exist after her marriage. She is no longer considered as a part of a father's family, rather she is considered to be a part of a husband's family. However, the contentions of daughter was, since she is now a co-partner in the Hindu joint family property according to the Amendment Act of 2005. So the factor that she was a woman which disqualified earlier her from being a Karta is now no more applicable or no more reliable to discard her the right of being a Karta to maintain her family. So the decision of the court was favor of the daughter. The court categorically stated that the section 6 of the Hindu Succession Act, daughter as a co-partner, if she is the senior most member in the family, would be a competent to be the Karta. They said the daughter, if she is the senior most member of the family, then she would be competent to be Karta, and the marriage of a daughter who is a co-partner did not alter the right to inherit the co-partnership property to which she succeeds after her father's demise, and thus would not affect the right to be the Karta of her father's family if she was the senior most member after him. So what has been concluded from this case is, a daughter is no longer excluded from the responsibility to maintain a family after marriage or before a marriage. She has equal right to maintain a family as that earlier was given to the son. So the Hindu Succession Act clearly gives a parity between the rights of a daughter and the son. There is no more distinction between them. A son can be a Karta, so as the daughter. But what happened in Indian society is, still the daughter has not been accepted as a Karta. Whenever she tried to come forward, the main contentions or the main statements released from the family is that you are no more a member after marriage. You are the member of your husband's family. They do not consider her as a member. So although through legislations and through judicial pronouncement, she is authorized to be a Karta, or she has the capability of being a Karta. Yet on the ground in Indian typical society of families, she is still not being considered to be more able or capable to maintain a family as being a girl. So still on the ground there is disparity between the rights of a daughter and the son, but the positive thing is legislations and judicial pronouncement had done with this disparity, and we hope that in ground we will be seeing it practically. So I hope you like this video. If you do have suggestions that how these rights can be put in at parity in the real society, do comment, like and share this video and subscribe to our channel. Thank you.